Welcome, folks, to the April 12th, 2017 meeting of the Cohasset Board of Selectmen. What we'll do is begin with roll call. Start with Jack.
Jack and Riley here.
Diane Kennedy here.
Kevin McCarthy here.
Paul Schubert here.
Steve Gomer here.
And we'll now do the Pledge of Allegiance and invite those who wish to participate to join us. I pledge allegiance to the flag of the United States of America and to the republic which stands, one nation, under God, indivisible, with liberty and justice for all. Okay, and what first on the agenda is any public comments from members of the public on any subjects that are not on tonight's agenda? And not seeing any, I'll go to the agenda for this evening, which is, what we have here is, we had a hearing which we closed and made our decisions relative to the noise matters at the 123 Elm Street in Cohasset, the Cohasset Harbor Group. And tonight what we're going to do is talk about what decisions we need to make relative to the license in light of the findings that we made. And so it's a continued decision entertainment license hearing on complaints regarding noise and disturbances at the Cohasset Harbor Group LLC, doing business as Cohasset Harbor Inn, 124 Elm Street in Cohasset. So with that being said, the way I believe we had left it last time was as both parties were perhaps going to get together and come up with some kind of maybe suggestions that would we could take into consideration before we make a decision regarding renewing and issuing the license. So could I get an update on what those are from both parties?
Sure.
If you would, please introduce yourself. Yep.
John, can I have my client come up, sir, as well?
If you wish. Yep. Can you introduce himself?
John Lawler.
Yeah, all do
Good. Okay. Welcome, gentlemen.
Thank you.
Thank you.
Mr. Lawler and I have had several discussions about possible options to address what the issues are, which basically are noise-related issues. We haven't come to any firm understanding on anything specifically, but you may recall back in January, we tried to work out a solution to some of the issues, and there were certain things that were tentatively agreed to then. I don't think those are in dispute. I've exchanged with Mr. Lawler some language, further language tweaking to the current license to address the issues that we have here. What I was going to suggest that we do is go through the license as exists with these suggested changes and discuss them and get feedback from the licensee.
Okay, so these are the changes that you've, based on all the inputs that you've had, you've put together for us, a sort of a summary of what this could look like. So, and then the ultimate objective would be is that we would come to some kind of agreement. The board would, if we on what the new license would look like and what elements of these would be contained in it. Okay. One question just before you start that is, I noticed that on the first thing is relative to general conditions applicable to all venues, and I'm just wondering, you know, since we've only got one place at issue here, if we shouldn't be focusing in on that one place, or what's appropriate here?
To amend any of the licenses, you'd have to go through an amendment process. I took the license for the Cohasset Harbor Inn, and that language was in there. So that was standard language that was in the licenses for Atlantica.
Right.
So I just took the existing license, which is what, you know, the unredlined language is, and that language was there. So if the board were to amend Cohasset Harbor Inn license, it would be, and you accepted, if you accept these changes, that even though it says applicable to all venues, would be we could just change that to Cohasset Harbor Inn, because we can't change the other
That's
licenses
my point is.
without a hearing on
Right.
those.
So just before I go, so to make it clear, if any changes it would be just for this license here, and we'd probably wanna change that title so it's not confusing, okay? Diane and Steve?
You may be the same thing, which is,
Yes.
I think in this thing, the general conditions applicable to all venues meant the actual inside of the inn and Breeza, which we were discussing as two separate venues.
Further, the construct of the original license, the language read, cell phone numbers of all managers to be made available to residents upon request. That was for all three of the locations. The basis for that was a continuation of current practice from the previous owners, which had worked well. The language that's being added here is not punitive, but rather declaratory. Here's how you're going to do it. If you want to strip that away from the others, I think you're walking backwards.
Well, I don't think anyone's talking about.
No, the proposal that I'm hearing from the board at the moment is to make sure that the red line language applies only to the Cohasset Harbor Inn, and I'm saying, no, the very basis for the original thought and language was to continue a practice which had worked. Ultimately, the goal here is to allow a business to be successful and live in peaceful coexistence with its neighbors. Nothing further than that.
Let's hear from council, because I think what we're talking,
I think we're probably saying the same thing, but my point being that we can't change the language of any other licenses other than the entertainment license for Cohasset Harbor Inn. That's what this proceeding was called for, and I don't think, and it may be when those other licenses come up for their next renewal, you may want to incorporate into those licenses whatever language comes out of tonight's meeting. We're not detracting from those existing licenses, but we can't go tonight adding to those existing licenses because there would have to be a separate
It occurs to me
process.
that we actually granted one license with conditions for 3 different places. Correct me if I'm wrong. It's an entertainment license
It's
covering
not-
Cohasset Harbor Inn, Brisa, and the Atlantica. That's one license with conditions for 3 different locations.
It was
Some of
one
those conditions were
entertainment-
general.
No, one entertainment license for each location. Each location has a distinct entertainment license.
Yes, that's my understanding.
Maybe Tracy can.
The conditions for those, the same,
They were
however.
the same, but they were
There were
separately
general overview
articulated.
conditions, right? All 3.
I think the point is, Steve, is they are separate licenses. All we can look at is what was the subject of the hearing, which is,
All right.
that's all. It's just legally, that's all we can do.
No, that's fair.
That's how it would normally be. First of all, Red Lion Inn.
Yeah, it has nothing to do with redlining. It's
Yeah,
nothing.
so it was just Atlantica and Cohasset Harbor Inn.
And Brisa.
Well, Breeza was within Cohasset Harbor Inn.
It has a separate set of conditions unique to itself. Page 1.
What you have there is from the Breeza, from the Cohasset Harbor Inn license, which includes Breeza and the rest of the premises.
Yeah.
Okay, so explain, if one more time, if the question is whether or not this can be amended, we're still talking about the same individual license. Now you're incorporating Breeza into the same license with Cohasset Harbor Inn because it's a contiguous unit, right?
The
So why
entertainment,
wouldn't we be able to amend item 3 as recommended?
you can.
That, the discussion that I'm hearing is.
No. Let me try one more time.
Yeah.
I think Kevin pointed out that the first line on this document says general conditions applicable to all venues.
Right.
And the venues are the locations within the Cohasset Harbor Inn, which include Breeza, which include the inn itself and any of the component rooms. At the beginning of the discussion on that, I may have confused things by saying that was intended to be boilerplate for the other locations as well, and it probably is under those licenses, but tonight we're only dealing with Cohasset Harbor Inn's entertainment license, which covers Breeza and the rest of the inn.
So where it says applicable to all venues, those venues are Cohasset Harbor Inn and Breeze. That's the legal
Yes.
definition of what that
Okay.
item is.
Is that clear to everybody? Okay, that,
I still don't think it's the way it was written. This looks like it's been amended from what we passed.
Go
The
ahead.
original document identified all three, and that's what I'm looking for. Heaven forbid we should actually be able to find it quickly.
Do you mean the Atlantic? I think the Atlantica was taken at the
Yes.
same time, right?
Yes.
So but you can't change the Atlantica's license.
My point is, it was in the same document.
They're separate licenses.
No.
The conditions were the same document.
Yeah.
This was-
Several
Yes.
of the conditions were the same, such as, I believe, the introductory thing, general conditions applicable for all venues. That, I believe, was in the other license that was voted. Tracy, were you able to pull the file?
No, so-
What's that?
No, I said I had them up yesterday, so I said. Do a search.
Well, looking for entertainment, I only get 400 responses.
Yeah, I'm gonna let you talk.
I think I've got the license right here.
There you go,
Yeah.
that's what we're looking for.
Is this what everybody's
Conditions.
looking for?
Yeah.
Was it
Okay.
the license for
Yeah.
Cohasset Harbor Inn?
Yes, that's
Yeah,
what we're
no,
here
I-
for tonight, right?
Yeah, I have, it was one of the, it was
So what's
exhibit
the, I don't
one.
understand where our delay is here. What do we,
I think,
do you wanna look at this?
Yes.
I think Steve was under
Go
the
ahead.
impression that we,
No, that's, okay, go ahead.
that,
And this is what, I just was trying to clarify, this is what we're here for.
this is
to
what
do.
we're here
This
for.
is the only
Cohasset
thing,
Harbor
this is
Inn.
the only document we're gonna be changing tonight, if we make any changes, that's all.
Yeah, this is my point, Kevin. The conditions are a contiguous document, that's all.
Or what?
A contiguous document, conditions, an addendum are a contiguous document. Here, they're amended,
Right.
and that's what I'm asking, is that proper?
But we haven't done any, those are just suggestions whereby we may change this. Is that clear? Is that right?
It's kicking me off.
Steve?
No,
So that's all that is, so don't worry about that in sense till we get to it. This is the thing, this is the only document we have. We may change this, but we're gonna discuss that, that's all we're at, right? All right, why don't we go ahead then? So,
Can I just get a point of clarification?
Yes.
Okay. So, just so we're all on the same page, and you may all be on the same page and I'm not, so bear with me. But it says in the minutes from the last meeting when we had the hearing, it said at the, I think it's on page 3, towards the bottom, it says, "At the suggestion of Attorney Lemke, the board agreed to hold off on the disposition until both parties come to an agreement on the license conditions." So we had this hearing that we concluded during our last meeting, and there were some violations that were found, in some situations there were violations that were not found. So, but in any event, there has been no disposition in regard to the findings. Is that accurate? That's accurate, right?
I'll let the counselor answer that.
The board, as you can read and see in the minutes, made certain findings about whether violations, whether the incidents occurred as alleged. And they found in all instances that the incidents occurred as alleged. Then the board moved into deciding whether or not those incidents constituted a violation of the entertainment license. And on the 4 incidents that were the subject of the hearing, the first 2, the board concluded that there was no violation of the entertainment license. On the other 2 items, the board did find that there was that it was the incident constituted a violation of the entertainment license, and that was voted. And as you just quoted, at the suggestion of Lampe, the board agreed to hold off on disposition, till tonight. So what we're addressing is, based on the 2 violations that were found, what is going to be the board's disposition?
Okay? That's what my understanding is.
Okay.
Okay? So, with that being done, then what I'd like to do is get a summary as to what you've agreed upon, or if you haven't agreed on what your proposal is based on all the input you've received.
Well, I'm not sure I can speak authoritatively as to what we've agreed on. We certainly generally acknowledge that certain things aren't a problem. I don't know if particular language, is an issue, but that's why I suggest we start right on the first page.
Yep. So what, I just want to frame this for my board, so to make sure that we're clear. So what we're at now is Attorney Lamke's gonna go through the license that we had, and then in the red here that we got earlier, the suggested changes that he's putting forward before us.
I think it would be beneficial, my client would like to speak for a few minutes and address some of his concerns and thoughts. That would give you some background here, and then that would, I think, would help when I start to deal with the specific recommendations and all that.
Okay, so what we'll do is, Counselor, do you have any objection to
No.
that? What we'll do is we'll hear from your client. After that, then I'm going to ask Attorney Lamke to go through this document, but without interruption.
Absolutely.
And then you can make.
Yeah,
We want to have an orderly meeting here. Then after that, you'll make any commentary you wish, at which point the board will make a decision as to what changes they want to make on this, okay? All right, so that being said, Mr. Orlow.
I just want to give you, not legal terms, I just want to tell you where we stand with the business, what I see is going on, and then a little bit about the plans, what I have for the business. It's just for the community, it's for you and when I bought from Peter the properties, there were no restrictions on the licenses. And the only restriction I agreed on, I wasn't at that meeting that night, was that we would close the doors at 8 p.m., which means the folding doors at the Cohasset Harbor Inn to reduce the noise. I cannot operate, this is now a $15 million business, I ran a $1 billion business. I could not operate the business under a restriction where a neighbor can call at 8 or 5 or 8 or 10 p.m. and say there's a noise violation. I spent $15,000 on lawyer's fees already for him on these hearings. And it cost multiple people their jobs. And if we continue like this, I cannot operate like this. And the issue is really, we gotta come to an agreement somehow where I understand the neighbors is right, but the businesses have rights in this town as well. And there is a difference between a license holder and operating a business. Take a Hilton. The operational managers are usually not the license holders. They are different people. And in my place, it's the same thing. I have operational managers which might not be the license holder. The license holder agrees to admit to the licenses as they are done, being the hours, being the regulations and all of this. But there are big operational managers, might be more qualified, might be not. It's like the Hilton. On the other hand, I want to congratulate you and Ms. Kennedy. There were nobody who put papers against you, which means the people like you. I will get deeply involved in the 2019 elections. And I will get involved and I urge the town not have one person negotiate the contract for the town manager or whoever it is selected or elected.
Excuse me, I hate to interrupt, but the discussion is supposed to be regarding
I just want to
liquor
give my
licenses.
opinion.
I don't think it's appropriate, Frank, for
Okay, I
you to
take
be
it back.
alluding to future town elections. That's not.
So, yeah, so do you have anything further relative to the business? Let's,
Are
excuse
you
me,
talking to me? You're not talking to me, are you?
I am, sir. You made a comment, and I just said,
Excuse me, you talked to
excuse
the
me, what
chair.
was your comment?
I just want to explain what I
Let's calm him
said.
down.
let's, let
Okay,
Mr. Olahide, excuse me, let Mr. Olahide finish, and we keep it restricted just to the business issue. If you're done with your comment, then we need to move on.
Can I just say something?
We wanna keep a current meeting here, but I think we're okay here.
With all due respect, I heard a
Excuse me, you
comment.
addressed the chair, Council.
Yes,
And you're not, I'm not
Mr. McCarthy.
recognizing you.
Okay.
I just
I want your client to finish his statement.
okay.
I just want to explain to you where I stand, okay, independent of the decision tonight. I'm running a $15 million business. It's tough. It's very tough. People lost their job because of those hearings. And if this continues, I cannot live like this. And the issue for me is very simple. I cannot live like Mr. Gomer put lot line. It's totally unconstitutional. And I'm looking at this and I'm saying, hey, look, I told him we are going, I gave him the authority to prepare a case for Superior Court against violation of my civil rights under the Constitution and personal prosecution.
This
I
is
just
supposed
want
to,
to let you
this
know.
is supposed to be conciliatory and addressing the license
So if
conditions.
you're
telling
done,
you where I stand.
right, and that's okay.
This
We
is
appreciate
close,
your
isn't
expressing yourself. We'll now go to the next section, folks,
Can I just recognize to speak?
very
please?
quickly.
Okay. Mr. McCarthy, I just want to clear up the record, because when I heard, first of all, I'm deaf in one ear, I'm deaf in my left ear, okay? I heard Mr. Kenley say something. I thought you were saying something for everybody to hear. I apologize if you were not. That's why I asked you. I
Let me
didn't
just-
hear the comment.
Mr. Chairman.
Okay, so go
So,
ahead, Jack.
please.
I'll let
You know,
let's-
when the selectmen are threatened by a citizen and a license holder in town, and by their attorney, I think it's improper. I make a motion, we close this hearing, and we figure out another time to schedule this when the license holder is in the appropriate frame of mind to talk about this,
I'm not
this
threatening
restriction.
anybody.
I personally had it. I mean,
Okay, all right.
And Mr. Chairman, I mean, we've gone out of our way this year not to disturb the way the license holder has run the liquor licenses. By law, by state law, and not by local law, you're supposed to keep normal operating hours every day, 7 days a week on all those premises,
Not
which you
7
have
days,
not
40
done.
hours.
Which you have not
40
done
hours.
for 7 months.
40
And we let it
hours.
slip because
John,
we
please
want
stand
you
quiet,
to
restrain.
make those places work. But when you come in and start threatening us, I mean, I don't
I'm not
understand
threatening you at
why,
all.
I don't even understand why we're having this hearing at this
Okay,
point.
well,
This was Boston, the
I
hearing would be
understand.
closed and the
But you-
licenses would be gone.
you've made your comment, and I do think we should move along. There is a motion, though, if anybody wants to second it.
My suggestion at this point, I'm not seconding Jack's motion, because I actually do think we should be taking some definitive action here. I wanna make certain, however, that we're not relitigating the facts of the findings which have already been made.
We're not.
And from that perspective, I simply bring about once again, so that not only the board recognizes this, but the operator recognizes this. The goal is to allow a peaceful coexistence for a successful business with the surrounding residential neighborhood.
That's true.
Okay? Simple as that. That's where we're coming
I
from.
agree.
Beyond the lot line does not impede anyone's constitutional rights, which belong to citizens of the United States. It's our Constitution. Now, from that perspective, I think we can entertain the verbiage that's here.
That's what I would like to do.
Thank you.
Okay, so what we'll do is move along from where we were. I want to respect the fact there was a motion, there was no seconding, I'm hearing of that motion, okay? All right, so we're going to move on then. And Mr. Attorney Lamke, would you proceed to go through the suggested changes?
Yes, okay. going by the current license that's in effect, no one so far is suggesting any changes to item 1. All applicable laws, rules, and regulations and conditions remain applicable. Number 2, the attention of the licensee is called to the Cohasset rules and regulations governing alcoholic beverages, and in particular, Regulation 27. Number 3 is the first one where there's a proposed change. It originally said, name and cell phone numbers of all managers to be made available to residents upon request. Back in January, this is one of the items that we talked about, and I think we basically reached an understanding on it. The proposed language that I'm recommending is, names and cell phone numbers of all managers shall be set forth on a list of managers. The list shall be distributed to the town, police department, and area residents, and shall be posted at the front desk, function office, and function room. Any changes in personnel or cell numbers shall be distributed to the foregoing. Employees shall attempt to respond to all calls concerning issues promptly and with courtesy. When appropriate, managers shall work with area residents, the town, and the police department to address noise and other issues. And not aware of any concerns from the licensee, but I'll let Mr. Lawler speak as relates to that suggested change.
Do you want to have him, you want to invite him to do so as you go through them?
Unless the board has some objections.
Okay, what I'd like to do is, when we're talking about the changes, to have a format, I want the selectmen to have a first shot at any questions you have. If you don't have any, then we'll go to the council, so it'll be a little different from what I previously said. And then we'll go through the entire document that way, okay?
That's fine.
All right, so, go ahead. Anything on number 3 here?
Mr.
You're
Chair?
first, yes.
I just would like to put some kind of a date certain for any changes in the distribution list. You know, make it 5 working days. They have 5 working days to change and circulate the phone list.
Yeah, I'd say 5 working days, after the issuance
5
of the
business
license.
days,
After the
yeah.
issuance of the license.
Well, no, I mean,
The changes,
any change in personnel or cell numbers shall be distributed to the
Very
foregoing
good, yeah.
within 5 working days of the change.
Sounds good to me. That would be phrased as 5 business days.
5 business days, sorry.
Sorry.
so we're gonna add, where it says, any changes in personnel or cell numbers shall be distributed to the foregoing within 5 business days of the change.
Yeah,
And by business days, that means Monday through Friday.
right.
I also think that it's a good idea that also apply upon issuance of the license. In other words, once we issue the license, we should see these numbers in 5 days too. I know it may be a little repetitive, but in other words, so that we don't issue the license and we're asking a month later, where are the numbers, because it wasn't clear in here. Does that make sense?
Yeah, but I think that would be
Possible.
covered.
That's covered?
Yeah, I think it would be covered.
That's fine. Anything else? Yes.
Yeah, I want to underscore once again, the most important sentence in this is the final one, which essentially is encouraging the management to work out issues directly with the neighbors, as opposed to making it an event, a hearing,
Yes.
working through the police department.
I'd like to, you done with that? I'd like to
I'm done.
reinforce that in that I will, because I don't know whether Mr. Oldhide was here at all the meetings, but one of the things that we heard consistently, I think, is that the residents were saying, if someone had gotten a hold of us, we may not be here. So that's, I really think that quick, easy, fast communication that you set up, and we can have, that's a good thing for your business, and we wouldn't have to have these hearings, so I do want to reinforce that. All right. Counsel, did you want to comment? Oh, excuse me.
I'd like to reemphasize that as well. I think that we've spent a lot of time, a lot of hours, a lot of evenings, a lot of nights, a lot of phone calls to get where we are. This could have been handled very easily at an earlier time, to sit down with local residents, and it would not have come to this level. The last line there under number 4, it says, managers shall be responsible for educating its staff as to the conditions and limitations of all licenses. I would like to see a schedule of the training sessions that are done, much like training of an ABC manager.
Okay, we're not
that
there
is
yet.
done.
We're not
No,
there yet.
sorry.
But you,
but that's,
let's do 3 first. Anything else on 3?
Yes, sir. The only request would be, we agree with everything that's set forth in paragraph 3. We just ask that instead of 5 days, it be 7 days, because Mr. Erdelheim just said they have weekly meetings every 7 days, so then the change is articulated. I mean, we'll try to get the information
I
out
think
as-
7 days okay with the
Yep.
board? Yep, 7's fine, thank you.
Thank you. Otherwise, no problem with that.
All right, so we can, 3 looks good. Let's go to 4. Mr. Lamke?
Yeah, I'm making the changes as we go
Oh,
along,
okay, yeah,
so,
take your time, do it right.
working off of the document that you have here. Number 4, management will be mindful and acknowledge the license is in an area abutting a residential district and shall remind, and here's what's added, hosts of all functions, the word and, then continuing on as it states, guests leaving the establishment, that they are in an area with residences and to exercise good judgment in terms of any noise. Management shall also be responsible for educating its staff as to the conditions and limitations of all licenses.
Okay, now there's a comment from the board member,
so
Paul.
what I would like to see is, much like when you train your ABC manager, there's a certain training that's done and it's designated and as disciplined, timed and dated, is to have a schedule of those training sessions. I don't care whether it's done over the course of 3 to 6 months, but it has to be done. It's gotta be done in a organized fashion, so
How about,
perhaps a schedule of the training sessions be offered.
okay, or, that's one option, or licensee shall certify to the board that staff has been so educated
That's
within so many months.
so many months of
Yeah.
whatever you want. Yeah.
You okay with that? Anything else from the board? So is that a change we're acceptable with, board? We're okay
Again,
with that?
the background on this, actually came out of the last session of this hearing, in which one of the wedding bookers had pointed out that she actually had no knowledge of conditions of the license,
Right.
and felt that the whole event was a surprise to her and to the guests.
Right.
That's the basis for it.
Yeah, that's exactly my point. I want to be clear that your staff is understanding of the rules and regulations and understand what we expect of them, and you expect of them as well. So they're disciplined enough and they're educated enough to know that these are what is required of a license. Not have just someone come in here on your staff saying, I'm unaware of it, I am not responsible because I was never told, educated, trained, whatever you want to call it. And that was unfortunate.
Okay,
So, going by what Dr. Schubert suggested, management shall also be responsible, this is part of what's already there, also be responsible for educating its staff as to the conditions and limitations of the licenses. Licensee shall certify within blank months to the board that it has so educated staff. So then the question is, how many months?
Did you read that last part for the?
Sure.
License.
Licensee shall certify within blank months to the board that it has so educated staff,
It's staff.
its staff.
so how many months would you think?
Well, the only thing is, it's within how many months from what?
Yeah, I mean, we're getting,
You know, I
Well-
mean, maybe once a year, twice a year.
Annually.
Well, actually,
Or annually.
whenever there's a new employee,
When a new employee's
they
gonna
have to
have to
make
be
the
educated.
new employee cognizant of these limitations. So
So that's,
within,
Well, wait.
If the turnover is fast.
but that's
then
not our
it's-
job.
No, it's not, and the prescription that we're looking for is to make certain that folks that are either booking the weddings or overseeing the events themselves, the management staff. Supervisory staff are aware of this. And, I mean, that's really the case. I don't know how you would prescribe it by way of time frame, but really, it's a certification under this license, certifying that our staff will be continually aware of this.
you'd use the term supervisory staff.
Supervisory booking, those folks, for instance, if someone's booking a wedding and the question is, can I put a band on the lawn? Well, they should recognize that under the conditions of the license, that's probably not gonna fly, right? So they're not over-promising and therefore creating discord with their customers. Our goal, again, is to create an environment where the business can succeed and live in harmony with their neighbors. I don't wanna run their business for them, I don't think that's the board's intent. We just wanna be certain that their supervisory staff and others related to representing their capabilities are aware of the conditions of the license.
So do we wanna have that for all staff or management staff?
I think it's unreasonable to expect that all staff, down to wait staff,
Yeah.
be aware of it, right? I mean, I would think at that point, if your managers are managing, they should have the situation in hand.
So, you say educating its managerial staff,
Do you agree or disagree?
managerial and supervisory
See,
staff?
one of the problems where there was the wedding supervisor wasn't necessarily a manager on duty per se, not an ABC manager, not a manager of the
Established.
Management of
establishment,
record.
but was running the, and that was the problem, was at least one of my concerns, is that before us, it was described as I had no idea what the results of, and what the regulations were for the license. You can't have that. Whoever's running it has to know, so whether it's the managerial authority of the venue, it's gotta be someone that's responsible, that knows the regulations.
I think if we said managerial and supervisory
That's
staff, that should be clear to the licensee. If we find in the future that it's not, then might have
We'll
to.
We'll have to
So-
revisit it.
So if you take the last line and you say, management is responsible for educating its staff on the conditions of the license, period. You know, I think if we become too prescriptive, it just
That's right.
gets, you know, this is an overall global, you're responsible. You know, if we find a situation where there's a problem and they claim as a defense that they didn't know the terms of the license,
Which
it's
is what
not,
happened.
it doesn't fly, it's a violation, right? Don't you, I mean, isn't that the
Yeah.
clearest way?
Yeah,
Yeah.
that sounds.
Okay. So, Jim, I just said, management is responsible for educating its staff on the conditions of the license.
As
I
to
just
the
took your last line and did a little bit of editing.
As to the conditions of the license.
I didn't say, I took out as to. You're a good Catholic boy, you must have been educated in a prayer.
No.
Probably
That's
not quite the
definitely
same.
a old-fashioned way of saying it.
So we're basically just rewriting Jim's last sentence, we're not requesting certification?
Yeah, we're just,
So we're
again,
not
I'm
gonna
just assuming
require
make it easy,
certification?
you know?
I'm happy either way, so we're not gonna, you're suggesting that we don't require like a written certification, which
If we do,
This-
we're responsible for tracking it, we're responsible for managing it.
So leave it in the general way that we.
Yeah, yeah.
okay,
Okay.
so I can take out that last part, but,
Do you agree, Chris? I mean, you know, I think it's more,
Yeah.
and.
Simple to resolve it, the easiest path, right?
Yeah. For educating, do you wanna still include managerial and supervisory staff?
I would just say staff. I mean,
Mhm.
whoever's, you know, working, everybody should know what the restrictions are.
Management is responsible for letting the staff know.
Right.
I don't think that's unreasonable. I mean, I think it's unreasonable to certify that there's been a training program for somebody that you might bring in on a weekend to help serve
But,
food.
see, that's my point, that was the problem, is that we had someone who was there on the weekend and going into the
That
wedding.
was the
and
event manager.
what- Whatever,
But
they're running the
She's-
event.
She's
and I-
management,
I understand, and that,
right. She should be,
and she should have understood the regulations and the stipulations within the license.
Right.
And it was clear to me, she
Right.
was unaware of any of it.
I agree, and I
So,
think this
I'm not
last
sure how to
sentence
word
does it.
But I'm gonna be firm and say if it comes back again,
Yeah,
and the defense is, I didn't know.
right.
I would suspect my opinion would be a little more coarse
Sharp, yeah.
as to
Yeah.
renewing
I-
licenses and considering further stipulations and restrictions on further licenses for any.
And
any
ignorance of
business.
the law is no defense, so.
Okay, are we agreed on the sentence?
Yeah, except I'm still not certain.
Why don't you read what you have?
Okay.
I'm not gonna get what I want, but I'll let them, if they want,
Well,
you know, the manager
I
and
think-
stuff, that's fine.
I think it's good to clarify it so that, you know, we're not talking about kitchen staff, wait staff, custodial
Managerial
staff.
staff, I
We're
think
talking
might be
about
fine.
different level of staff. But management shall also be responsible for educating its staff as to the conditions and limitations of the licenses. It sort of begs the question, and the example you gave is a perfect one, because someone testified they knew nothing about the conditions. So
Well, that's not a defense though, right? I mean, under
it's
the
not a
general
defense, it's more of
conditions.
a practical recognition that we're not going to have a problem if the busboy doesn't know the conditions of the license, but we would have a concern if the function manager or someone else didn't know the conditions.
I mean, we need to have a good execution of the license, and to me, that was an example that it was not being properly executed, because you had someone that was in a managerial staff level that was completely unaware.
I totally agree.
I'm not
So-
sure how to-
So
I
I'm
guess-
in violent agreement with your analysis.
I'm not sure how to.
Yeah, and I'm
word
just
it, but-
saying, instead of saying shall, we say management is
Oh.
is responsible for educating its staff on the conditions of the license. I mean, it just,
Yeah, that's fine.
you
How
know,
about it to cover what you're saying, staff and other responsible people,
Parties.
parties?
There's, I think at that point,
it gives you a loophole,
it's a complete, you know, your staff is, you're on the payroll.
your staff.
Well, that was Paul's point,
I
is
mean,
if somebody
you have
was
a-
off the
so you have
payroll.
a
So-
1099 employee, that's a contract.
So what if everybody walks out some night and the dishwasher ends up being the supervisor of the wedding? You know what I'm saying? I mean, this would cover that.
Okay.
Well,
Could
there's a
happen.
whole
All right, so,
host of
'cause we
violations that
got
just
a-
happened.
So
I could,
now reads, and I understand better if Jack wanted me to make a change on, management is responsible for educating its staff as to the conditions and limitations of all licenses.
Fine,
Fine.
that gets the point.
That's good.
Okay, that's number 4. Counselor, are you okay with that?
Yes, I mean, I think I'm fine with the language, I'm not clear exactly how it reads, but,
Maybe,
because I don't know if you bear with me, I don't know, are we still gonna say licensees shall certify within
No.
certain
No.
months? So that's out?
that's out.
Okay, okay. The only other thing that I would recommend adding to that, and it could be in parentheses, and I just think it gives clarification, is that the Cohasset Harbor Inn is not responsible for noise outside the premises of the Cohasset Harbor Inn. Because if we remember, and I'm not relitigating any of the matters discussed in the violations, but if you remember, there was some discussion, actually, and Attorney Lemke withdrew it, there were some complaints about noise that came from outside the American Legion Hall and also in Veterans Park. And clearly, I think it should be articulated that Cohasset Harbor Inn is not, maybe we can tell people, hey, look you're in a residential area, but once they're beyond the residential area, I think it should be clear that we're not responsible for that.
Yeah.
Is that a fair statement, or maybe not?
I would respectfully, I understand what your point is. I don't think you can be held responsible under most circumstances for noise coming from someplace else. However, under the entertainment law, if you have a situation where the licensee failed to prevent an unreasonable increase in the level of pedestrian or vehicular traffic in the area of the premises, or unreasonable increase in the number of vehicles parked in the area, or prevent an unreasonable increase in the level of noise in the area caused by the licensed activities or caused by patrons entering or leaving the premises. That's in the law. I think it's gonna come down to a fact-specific situation. So I would not recommend that language be
Okay.
included.
I have the same impression too, so we're not agreeable to that, so we're not gonna agree to that. So anything else on 4?
No, sir.
Thank you.
Well, Mr. Chairman, I just want to say too, we're not trying to make this punitive, right? I mean, we're trying to figure out a way for them to conduct their business and for the neighbors to be able to have quiet enjoyment of their property, right? All we want is for the owner of the business to cooperate with the police and and
And the
supervisory
resident-
personnel to make sure we get this stuff
Yes.
resolved. You know, we don't want 20 minutes of loud music where people are, people can record it on their iPhone from 500 yards away. I mean, we're not gonna sit there and say, geez, you know, you made a lot of noise getting into your car,
Right.
you're out.
Right.
That's not what we're doing.
Right, okay. Okay, let's go to the next point, which is under, where are you at next?
The next point that I have here is number 5. A suitable staff person shall be tasked with the responsibility to ensure that the doors are kept closed.
Excuse me, where are you in number, because
I'm
only
wondering
got
myself.
we've got 4 points here.
Oh,
This is the end of the general conditions.
I'm sorry, my bad. Okay. All right, that was the end for general conditions
Right, we're
applicable
at
to all
venue.
venues.
Right.
Now into venue Breeza.
Yeah.
It starts off by saying, no amplified music on the patio, that's an existing condition. Number 2, any non-amplified music on the patio must cease by 10 p.m. I think that was intended for acoustical or soft music that they've been playing out there that's non-amplified. Number 3, number 3 originally said doors, including accordion doors leading to the patio, must be closed by 8 p.m. except for ingress and egress. I'm proposing that we clarify it, make it clear that windows and doors, including the accordion doors leading to the patio, must be closed by 8 p.m. except for ingress and egress. So we're adding the word windows and in front of the word doors. And let's take that one at a time. Is there any issue over clarifying that?
Any issue, folks? No, what's that?
The other sentence, trying to address what the problem seemed to be, is to add, doors and windows shall be closed whenever amplified whenever amplified sound, it should be, take out the word music, amplified sound produced in the function room will be audible beyond the lot line.
Okay, board, are you okay? Any comments on that? All right, that seems fine with us. Joe, would you like to make a comment on that?
Yes, sir. Thank you. I just want a point of clarification, excuse me, on point 1, where it says no amplified music on the patio. I think we had some discussions, and Attorney Lamke and I disagreed about music that was inside and then came outside on the patio. I thought, and I'm not trying to, draw any conclusions, the board obviously has their own conclusions, but I thought the board agreed with me that music from inside that came out in the patio was okay. And I believe that was articulated. I'm not
Okay,
putting
with
words
Diane
in
first.
anybody's mouths.
Diane?
That was my understanding when we drew up the conditions. We were discussing Breeza basically as a restaurant venue. And, and that's why it's till 10 p.m. was that if somebody was there with a guitar or something, or just, providing kind of background music, that was gonna be okay with us, assuming it shut down by 10. So we were very specifically talking about an amplifier speaker on
Speaker
the
on the
patio.
That's my reading on it as well, Dane.
Me too.
Having an amplifier stuck on the patio that was
Right.
booming.
Right.
Yeah.
Right.
Having said that, I'd like to point out that the spirit of this is not to make the Brisa service floor an 8 p.m. disco, because the music is amplified from behind the doors,
Well, and
right? Ultimately, that doesn't solve the problem, it just provides another point of friction.
But that's line 4.
Right.
Okay, I'm just making the point.
in line 4.
Okay, so I think we're in agreement.
Just the intent was, I think, when we went through the chronology of how a wedding occurs, for instance, and there's a cocktail party that goes from 6 to 7, and there was gonna be music that was basically played inside the hall, or the venue. And we're fine actually with turning, we'll come to this later, we're fine with turning the speakers around so the noise goes back inside rather than it goes outside. We're fine with that. But I just, again, to me, it's, and I think we're all in agreement, we're not gonna put the speakers on the patio.
That's what we're
But
up with.
there will be some,
Okay.
quiet music that comes out during, for instance, a cocktail party, and
Right.
so conversation can occur at the
It's
same
kind
time.
of incidental noise on the patio
Right.
because it's amplified music within the
Right.
function room.
Right,
Once again, and if I may add to this board is trying to act in what it believes to be the best interests of a successful entity in cooperation with the neighbors. Ultimately, we can only adjudicate based upon what's on word here. But I have to tell you that, and I hope again that your client comes to fully embrace this. Simply communicating with the neighbors, in all likelihood, will provide a much greater level of flexibility for that entity than anything that we can write up.
right. May I just add to that? I mean, I don't, I think you're aware of that, sir, that at some particular point, I think a couple months ago, all the neighbors were invited to the Atlantica, and Mr. Wharton at that particular time, addressed certain issues and talked about, again, I wasn't at that meeting, I don't know, but I know a half dozen, 8 neighbors
Right.
attended.
Nor was I think it's a great first step.
Okay,
That's that's the beginning of a process.
sure.
Right?
Can we-
So, okay. Thank you, Tim.
Just to note about that, it's certainly a good idea to communicate with the neighbors, but, it has been represented to me by a couple of people at a minimum, that at that meeting, the residents were threatened with a lawsuit if they called the police to complain. So I hope
It's the
that,
carrot and stick approach. I see.
I hope
They better not run for election.
that, while I think the town encourages businesses to cooperate and have good relations with the neighbors, and neighbors to have good relations with their businesses, that type of communication is, I don't believe is what the town has in mind.
No, that's not quite the beginning of the
No,
process.
that's no.
All right, I'd like to get focused here. You change that language to reflect what the board is in agreement to. We okay with that?
Yeah, windows and doors, including accordion doors leading to the patio, must be closed by 8 p.m. Okay. Then the other sentence that I propose being added here, doors and windows shall be closed whenever amplified sound produced in the function room will be audible beyond the lot line.
Okay, we all set with that, folks?
Yeah.
All right. Takes care of that. We can go to the next.
No,
page.
I have a strong
Oh,
objection to that.
I'm sorry.
We can't live with that. And that's our position. I mean, it's just, it's unreasonable. I mean, let's just think about that. I mean, if you're basically in a neighborhood, and you have a neighbor across the street, and you're out your front door and you yell out, in the morning, "Good morning" to your neighbor, "Good morning, John." I mean, you're in violation of that particular regulation that you're putting on the Cohasset Harbor Inn. I mean, it's so subjective.
No.
No. There's a big
It's
difference
gotta,
there.
can I just, it's gotta be a reasonableness standard. If you
Well, in
just.
terms of reasonableness, can I just say here, it says amplified music. It doesn't say saying hello to a neighbor and so forth.
Doesn't say.
It says doors and windows should be closed whenever amplified music is heard beyond the lot line, and that's just what we don't want. We're not covering all that other stuff that you're talking about. We don't want amplified music beyond the lot line.
There's-
Well,
With
I think that's
respect,
what we're saying, yeah, anyways.
Yeah. Can
I just.
All right,
it's
we're gonna
too
do Paul.
I, no, Steve first, yeah.
Okay,
subjective. I'm
Steve.
sorry.
with respect, I understand that the owner of the business would like the ability to use his venue with the greatest amount of freedoms possible. The fact of where that building was constructed and where it faces is what he bought. These were original, the only thing that changes here is the position of the sentence. Up to this point, these conditions were agreed to in their previous form in this language. So there's no surprise here. I'm sorry if he wasn't present. It wasn't even in this hemisphere at the time when these were conducted. But I do
I'm
know
sorry,
that phone
what?
conversations went back and forth with your client at that time. And the net result is what was in the original document and is repeated here. The difference between me yelling out to you, "Good morning, neighbor," is no one paid me $50,000 to do that, right? Someone is paying for an event, and that's a professional conduct, which can disturb the neighbors. I think we all agree that's possible. And it's especially possible when you open one piece of your building, project sound at an amplified level out over the water. Unfortunately, that's the way the building was built, and I can't change that. I don't know what his solution might be. I don't care if behind closed doors, so long as it doesn't disturb the neighbors, he has a Metallica concert. That's not an issue. The issue is, can it peacefully coexist with the neighbors? And up to this point, the one thread that we have understood that has worked with the previous owner, who also operated a wedding business, was that those doors would close when the noise was disturbing to the neighbors. And that's the basis for it. Audible beyond the lot line.
Okay, any other comments?
No.
All right, is this what we want board to stay in here, this way?
Yep.
All right. We're gonna move on then.
Okay.
4.5,
The next, item number 5, a suitable.
4.5, oh,
No,
5, yes.
yeah, we know.
Yeah, I'm sorry.
A suitable staff person shall be tasked with the responsibility to ensure that the doors are kept closed by 8 p.m. or earlier if amplified sound produced in the function room will be audible beyond the lot line.
Okay, any comments from the board on this?
My,
Diane?
my only comment is we didn't discuss 4, but 4 is remaining the same.
Right.
I'm sorry, that's correct, yeah.
I just wanted.
Patio, yeah, patio is to remain, number 4, patio is to remain primarily a dining venue with dancing permitted as an incidental activity. Wedding ceremony shall be considered as an acceptable use of the dining venue. And that was in the license that was approved back
Yeah, and
almost a year ago.
right, and I just wanna say, this,
Yeah.
this actually was something we spent a great deal of time on making, I mean, we talked all about what constitutes dancing. You know, if there is a guitar player there and you're doing this, you know, I mean, we literally talked about swaying back and forth to a guitarist maybe while you're eating dinner, so, this, you know, this should come as no surprise. But it does say it's primarily a dining venue.
But
because
that's from the
how
original, that's the original language.
Yeah.
That's
Yeah.
what we
And that's
originally
what was
approved the license
represented
on.
all along.
Yeah, that's
Yes.
original language.
Yep.
We have no objections. Thank you.
Okay, and then he just read the,
Yeah,
number
so,
5, any questions on this, folks?
so on 4.5,
It's 5, actually.
oh, okay,
Looks
sorry,
like 4.
sorry, 5. On 5, I'm not gonna tell you how to run that staff person. There are lots of descriptive terms for it: doorman, bouncer, maitre d', runner, lots of ways to do it. Someone who is independent of the general wait staff, which can police the area, closing the doors, shepherding in guests in and out, greeting them as they come in. And the doorman is typical, you open the door, you greet the guests coming in, you give them, you know, a handshake, you say, hi, welcome to the wedding. That's the sort of information, that's the sort of person that it would serve that business very well. You can call him a floater, you can call him a bouncer, a doorman, whatever. That is what, that line would be extremely important to help running and controlling the noise, controlling the doors, controlling the crowd. And so I think that is tantamount to run a wedding and to keep the sound and the noise down.
So you're fine with it?
So I'm fine with
Safe,
that.
yeah.
I just want to reemphasize that is a very simple thing to execute.
All right, any other comments from the board, Jack?
Mr. Chairman, I mean, what would the difference be if we used a suitable staff person will be tasked instead of shall be tasked? I'm,
Shall is usually a stronger word. It's
Is it?
usually a stronger word.
Shall usually, yeah,
Legal
more
Yeah, we do that.
mandatory as opposed to directory. May is directory,
Shall is
shall is
legally is-
mandatory, although there are exceptions to the rules.
Which is what keeps lawyers in business.
right, so,
Okay.
you know, not being a lawyer,
That's all right, that's all right.
That's why I have-
Anything else from the board?
No.
Any commentary, counselor, on this? We look like we.
Five.
Yeah, I do have a problem. Again, it's our position that the audible beyond the lot line is unreasonable, it's subjective, it was never agreed to by my client. I mean, the same reasons that I articulated earlier.
I think, I think this is saying that you have a certain responsibility if amplified sound produced in the function room will be audible. It's not saying it cannot be audible, it's saying that a suitable staff person shall be tasked with the responsibility to keep the doors closed if the sound from the amplified sound will be audible
Right.
Beyond the lot line.
beyond the lot
Yeah,
line.
then that's where we have the problem.
I understand,
Again,
but
the
we've already-
subjective standard, you know, is it 1 foot from the lot line, 1 inch from the lot line?
So we're gonna leave, I think the board is we're gonna leave that language as it is.
Right.
And hopefully, with common sense, and that this will be,
It's gonna result in an appeal, sir, but that's fine.
whatever, we're gonna stay with the language unless the board wants to change it.
No, I just want to comment that it's under the venue Breeza, line 3. It's the same.
It's the same
Audible
language that
beyond
was
the
in the
line.
license
Same
that
item.
was
Right up above.
It's
frankly
saying
agreed
mostly
to
below.
back in
originally.
June,
Right.
when the license was
Okay.
approved for transfer.
Steve?
Now, I wanna make sure it's clear. First of all, licenses are privileges and issued by the licensing authority. They're not negotiating factors. Number two, in spite of that, this board and licensing authority, as it's currently composed, spent a great deal of time on this license. And parties representing the owner were present and actually had to leave to communicate with the owner, came back representing that everything was good to go. So I would say the board showed deference up front. And at this point, the board's quite willing to accept that if you wish to appeal, we're good by that.
Okay. I mean, I just
I
didn't-
never agreed
That's
to
not
the
a,
lot line.
it's not yours to agree to, it's ours to issue.
No, I
And it was
understand
agreed
that.
to by the representatives of the licensing.
It was, but that's neither here nor
We're
there.
not gonna be debating,
Counselor, that's neither here nor there. The licensing authority has the authority to set conditions, period. It's ours to defend. It's not to negotiate.
But
to set
I never
conditions.
heard about it. The only thing you asked me,
Yeah, then your
do
telephone's
I
not
agree to close the doors at 8 p.m.
Then you might want to
And
talk
I
to your
agreed
staff.
with that.
You might want to talk to your staff.
I don't think we need to pursue.
That's my point.
The staff had nothing to do
It
with
was, the record is
I'm the
clear that this was
licensee.
discussed before
show
and
up.
agreed by the licensee.
Okay, what I wanna
The
do is,
licensee wants to make a request to change it, they can submit a petition
alright,
to change.
this is number 5 here, and you made your point. Counselor, does the board wanna continue changing that, or we're gonna
No.
stay with it? Okay, alright, so we'll stay with that at this point, and,
You made your point.
the next
Major
point is,
point.
the next one is venue in and all licensed premises.
Entertainment is permitted, and this is the same language that was in the original license. Entertainment inside until 1 a.m. Monday through Sunday, so long, the other one said as long as, or so long as it is not audible beyond the lot line, except caused by temporary opening and closing of doors for ingress and egress.
Okay, does the board have anything else to comment on this?
That's language, yeah.
Yeah, alright, Counselor, do you have any comment on this?
Yeah, it's just the same comment
Same
that I
comment.
made in regard to audible beyond the lot line.
Alright, board, we set on this?
That's,
Diane, you trying to say something?
No, I'm not gonna hold it.
Unless, one thing I wanna say is we don't need to repeat our same things, okay, folks?
Yeah, no, let's.
Because we're gonna
just
be
wanna
here.
reiterate, that was in the current, that's in the current license, even though it shows up in red on the document you have, it's only because I was moving other things around. That
Okay.
language is, other than preposition of as instead of so, is the same as in the current,
Okay, and
license.
it's acceptable to the board here, without a vote yet. Okay, go to the next one, please.
Okay, next one, windows must be closed. That was, again, this is in the original license, what I'm gonna read. Windows must be closed while entertainment license is being exercised. Doors to be closed except for ingress and egress except for accordion-style doors leading to the patio, which shall be closed by 8 p.m. while the entertainment license is being exercised. That's in the current license. I propose that we add further clarification. All windows and doors shall be closed whenever amplified sound produced in the function room will be audible beyond the lot line. Again, that is new language for that paragraph. The original license states, just as in number 3, that the entertainment is permitted as long as it's not audible beyond the lot line.
Okay, so you're really, essentially this language is supplying the concern that we had relative to beyond the lot line to the inn.
It would make it clearer.
Yeah, you're making it clear again.
Making it clearer.
All right, board, is there anything to comment on this? All right, counsel, would you like to comment?
Yes, sir, please, thank you. Again, I object to the language, all windows and doors shall be closed whenever amplified sound produced in the function room will be audible beyond the lot line,
Okay,
for the reasons stated earlier.
yep, thank you. Anything else, folks? The gist I'm getting, we haven't done any votes yet, is to keep that, is that correct?
You can do it that way and just vote in one final motion.
Yeah, we're not gonna vote yet. Okay. Next item is,
Number 3, which
It's like a repeat of
it's a
one.
repeat of, yeah, I think what happened was that I moved what was
3 to 1.
what was that one up there.
so we're gonna cross out
Get rid of
3?
Yeah,
So strike 3?
Yep.
Three's being crossed out. Counsel, you okay with that, I presume?
I am, thank you.
yeah.
All right, if you go to number 4, which is now number 3 apparently. The next one.
Yeah, okay,
This is identical.
This is the same thing as,
You just call it management shall be tasked with management shall have the responsibility to ensure the windows and doors are kept closed by 8 p.m.
Where are you?
I'm trying to
Four.
find
Number 4.
number 4.
where I am here.
The suitable staff.
A suitable staff person, but
It's identical language to the previous one, so
Yeah.
if we change this, we need to change the other one
I
too.
do agree with Jack, I think it's a little more artful to say management shall be tasked, I mean, somebody's gotta be the final.
And it really should be, management shall be shall have the responsibility to ensure, do you know what I'm saying?
yeah. Well, the idea was that management, which is the management of the licensed business and the license holder, has to designate, they're not there, 24/7, or whenever the place is, always when the place is open, but a suitable staff person should be there whenever the place is open.
I think that's.
That was the idea.
And the implication here is that
That's
management is responsible for this anyway, so I'd say we could leave this.
And Paul articulated it earlier, that, you
There's
find,
lots of ways.
you designate somebody to have that responsibility
A
within
suitable,
an event.
Okay,
So
so,
you wanna make the point that the person's on premise, so I think you need to say something about, there is a person on premise that's responsible for managing that. Do you know what I'm saying?
yeah.
Because that's the point you wanted to make,
So
A
right?
suitable staff person
On premises.
on premises shall be tasked with the responsibility to ensure that the windows and doors are kept closed by 8 p.m. or earlier if amplified sound is produced in the function room will be audible beyond the lot line. So a suitable staff person on the premises, okay, shall be tasked with the responsibility to ensure that the windows and doors are kept closed by 8 p.m. or earlier, or by 8 p.m. or earlier if amplified amplified sound produced in the function room will be audible beyond the lot line.
okay, you got it?
Yeah,
You'll probably have to modify the number 5, a
Right.
suitable staff person on the premises, on the previous.
yes,
Number
yeah,
5 from-
yes. A suitable staff person at the top of that page.
Yeah,
There's the parallel.
just make sure it's the same.
on
Okay,
the
is the board okay on this?
Yep.
All right, counsel, would you like to comment on?
Well, could you just read the whole thing to me, how it reads now? Curiosity.
Sure. A suitable staff person on the premises shall be tasked with the responsibility to ensure that the windows and doors are kept closed by 8 p.m. or earlier if amplified sound produced in the function room will be audible beyond the lot line.
Okay. I'm fine with all the language up until 8 p.m. I object to the language or earlier if amplified sound produced in the function room will be audible beyond the lot line. I want to go into it just for a moment and explain it a little bit more in detail. We're not opposed to language that would allow that sentence to still exist up until 8 p.m., but I would prefer language that would say when the amplified music reaches an unreasonable level. I think, again, that this audible beyond the lot line, that's really what I call an arbitrary and capricious standard. And it can't be enforced in a fair and equitable manner. The whole idea here, and I think we all agree, is basically to allow this business to coexist in the neighborhood. And we want to make sure that the noise does not bother the neighbors, right? And that's what it's all about. So if the amplified music goes an inch beyond the lot line, or a foot beyond the lot line, or out to the sidewalk, or whatever, that's not disturbing. So it's really arbitrary and capricious, and it's not meeting the goals that what these selectmen should be really concerned about. So I'm not objecting to taking special measures if the amplified music reaches an unreasonable level. And again, we're gonna have a noise engineer or sound engineer come in and try to reduce the noise, turn the speakers around, and all that, which I think is fair and reasonable, as opposed to the standard that you intend to agree to tonight. Thank you.
So, Mr. Chairman, I mean, think about it, the burden, so if you have to prove it was audible beyond the lot line, you just need 3 people to stand up and say, I heard it. You're done. If you make it unreasonable level, it's a much more negotiable term of art.
I disagree.
And I'm not against it, I mean,
I disagree with that descriptive, that is unreasonable, because what's unreasonable to you may not be unreasonable to me and vice versa.
right.
And so that's where the issue lies. Ultimately, our role here is not to be the noise police, but to lay down a standard whereby there's an expectation projected, an expectation of behavior, of good faith. Beyond the lot line, well, okay, but how about beyond 50 feet under the water? Well, who's gonna go measure it, right? Because what happens effectively is that the sound leaves that building, bounces off the water, and you could be sitting at that party on Bassing's Beach. You might as well be there. It's just as loud as if you're inside the room. And that's what happens. That's the structure of that business. I don't have the answer. I don't believe for a moment that the selectmen have any particular interest in sitting in a dinghy at high tide on Inner Cohasset Harbor, waiting for the music to crank so that they can lob in a complaint. Nor do the neighbors particularly care, whether or not the joyous wedding next door is a twitter about whether or not the police are coming. The neighbors, frankly, have peacefully coexisted with that business for some time. If we've got better language, great. But in the meantime, the language simply projects an expectation. And I do, given this is a small town, personally know many of the neighbors. And I also know that those neighbors, because they've expressed it to me, sit there and make it very clear. They just want to live in their homes. They don't want to be cops on this business either. They just want to have what they had had with the previous owner, which was a peaceful coexistence and an awful lot of communication.
Okay.
So, there.
Diane?
Yeah, I think the real issue is number one under venue, the inn. Because all we're asking for in 3 and in 5 is somebody to manage the doors and windows if the noise extends beyond the lot line. So if we're going to spend some time, and it's probably worth trying to find the right language for it, to just, to either address what we're looking for, what the neighbors are looking for, and what Attorney Lawler is reacting to, it would be to do a better descriptive in terms of whether entertainment is permitted at all beyond the lot line, and what that might mean. I think that's the place, if there's gonna be a discussion of changing some language, that's where it would be. I mean, I remember during the hearing, some of the neighbors had video of when the doors were shut. And there was maybe some residual noise from standing out on a porch with a thing, that you could hear something was going on in the building.
But it was-
Or was it completely silent, you know what I mean?
No,
So I think they're fair and reasonable.
the video was making the comparison between the
Doors
previous high
open.
level of noise
Right,
and now
Reasonable.
reasonable silence.
right, which is the bright line, I think, that maybe we're missing here in the beyond the lot line, because one could argue that standing out on Summer Street with your cell phone, recording that building completely buttoned up with an event going on in the function hall, there may be some audibleness,
There-
if you will.
There may be, but no matter what,
Right,
in such a circumstance, it's still gonna be the matter for this board to adjudicate those circumstances. And I would like to think that the board has a reasonable standard from that perspective. Yes, you probably, at any given time, you probably can stand out, right at the triangle and hear plenty that's going on. But I doubt that someone watching a movie in their bedroom is going to be so disturbed by that they're going to be willing to pick up the phone and call the police. And in fact, the incidents that were brought forward to this board on these occasions were enough to summon the police on several occasions. In one case, several occasions in one night. That's a whole lot different than simply being able to detect sound.
right.
Right, but I think that what the licensee's concern is that they don't wanna live under an environment or the possibility that any kind of noise is something that they can be held liable for. I think that's what you're saying, right?
I think it's absolutely right, and to follow this by the letter of the law is basically, excuse me, it's a death knell for weddings at the Cohasset Harbor.
So how about this? Can I just, Len, do you mind if I?
No.
Because I haven't. The real concern with the licensee is this audible being held responsible, and maybe unreasonably so, or what they're concerned they have to live with. How about if we made it, the sound produced in the function room, it would be a suitable staff person to be tasked with the responsibility to ensure that the windows and doors are kept closed at 8 p.m. or earlier. If amplified sound produced in the function room will be audible beyond the lot line at a level which is inappropriate for the residential community,
Who's gonna make that
In which we reside.
determination?
We
Well-
are,
Us,
we are.
I guess that's the point.
Well, the point is one way or the other, it's gonna be relative. I mean, we're not gonna be able to make this, so we either, if that's acceptable to them, what we're saying, and what I think we heard from the neighbors, and what would be reasonable is that there may be some kind of noise coming that you hear, but if it's not disturbing or inappropriate for a residential community, then I don't think they were indicating that they would object to it, nor can we possibly stop that, but that may make this in such a way as the licensee would be agreeable to it, if they would be agreeable to this kind of language. So why don't we do Paul first and Diane?
I would, understanding that you're worried about unreasonable loud noise going across as being unreasonable, I would just place one word where it says, sound produced in the function room will be unreasonably audible beyond the lot line, and that would be, I mean, we saw the video, there was unreasonable noise, there was reasonable noise, and the closed doors, even at 8 o'clock, you can live with it. I think if you just put in unreasonable in that,
Well, I could live with that if the council could, but Diane first.
that's exactly what I was gonna say, and I just wanna reiterate, I think it's most important in number one, where it's, and just to add, so long as it is not unreasonably audible beyond the lot line. I mean, there's always a wiggle room of what's reasonable, that's what the
Right.
law is based on. And we could add unreasonable also in 5 up at Breezer and 3 here as well, but I think it's most important in 1.
That would do it for me.
Any place you make the change about the lot line, we'll make it
Make it the
consistent.
word reasonable.
Couple other variations perhaps. You could specify so many feet beyond the lot line.
I'd rather not get into that, cause that's measured.
Depends on the
We're
atmosphere
comfortable
of the
the way it
night
is.
and.
Laser pointer's not
um,
accurate, and
The other thing is, it's not so much language to propose, but just to make a statement that whatever you come up with, if the licensee finds that they're being cited unreasonably for violations, they can bring this back to the board and say, look, this wasn't the intent, we're being unreasonably cited, but the police as the enforcing agent would be the ones, or this board would be the ones to say, yeah, this is a complaint that we're going to address through a hearing, or they're gonna say, no, we just don't find that to be, unreasonable. So we'll give the licensee, always has the opportunity to come back and say, hey, something's not working.
I think that's fine, but I'm not feeling a need to put that kind of language in this right now. I think if we make this simple and get the word unreasonable in there, that gives protection for what they're concerned about, and that elegantly solves the problem, and I wanna hear from Counselor Lowe. Would that solve it for you? Certainly is an improvement.
It certainly is an improvement. I think it's okay, and my client left because they
Right.
thought you weren't gonna bend on that, I think. So I would, when the whole thing is done, and we type it all up, I mean, it seems to be,
I think if we, I
it
hear.
seems to be a reasonable modification, put it that way.
All right, I'm hearing from the board, that's very good, that.
We're gonna add the word
Make it reasonable.
unreasonably audible.
Yes.
Everywhere.
Okay.
Is that good language though, unreasonably audible?
it's an adverb.
It's not the greatest in the world, but it'll cover,
It's grammatically correct.
If I can just, throw the lawyer in part of it, there is, like, for instance, whenever you deal with negligence cases or whatever, when you're given jury instructions, there's always the reasonable man standard, and malpractice case, reasonable physician,
Yeah.
reasonable lawyer, whatever it is, I'm not gonna, but, so that's a common term, reasonable man standard, reasonable person standard, reasonable, man
So-
including man and woman, obviously.
Yep.
If I can say, and when you saw the video, I think reasonable noise was what we saw when the doors were closed, and that's okay. And then it was unreasonable when it was loud and boisterous and all the rest of that. I think the neighbors just wanna be able to just enjoy a summer evening and not be blasted out of their homes. A simple
I think that language.
sound across there, I think is fine.
And this
That's
covers,
where
Just wanna
and this,
remind
think
the
that's
board,
where
that was
we're
a
at.
Sunday night on a school night in
Right.
September.
Yeah.
Right.
That's a factor too, whether that's reasonable to have noise.
Right.
and that's
Sunday
something that,
night
if
on
it comes
school
back
night.
to us, we as a board would be the determiners of that. And over a period of time, the way this works is, we'll, by 10 decisions, which hopefully we don't have 10 of it,
Right.
we'll establish what's called a common law on this. But
And that handles-
that's down the road.
But that handles something like 4th of July. I mean, it's 4th of July
Yes, it
night,
does.
what's
That's
reasonable for
reasonable.
4th of July versus
Right,
a September Sunday.
okay,
Or
Counselor?
St. Patrick's Day.
So I'm adding everywhere where it says audible beyond the lot line, the word unreasonably.
Yes, good word, good, okay?
1 second.
Yeah, take your time, do it right.
I think I got it all. Unreasonably, would be unreasonably audible, unreasonably audible, unreasonably audible, unreasonably audible. Okay, so now, that was number 3.
Yeah.
Suitable staff present on the premises will be tasked with the responsibility to ensure that the windows and doors are kept closed by 8 PM or earlier if amplified sound produced in the function room will be unreasonably audible beyond the lot line.
Yeah, that's it.
Okay. and I added
Everywhere else.
everywhere else. The next item is number 4. Licensee shall confer, this is a new language, licensee shall confer with the police chief as to the nature of any functions, and when so recommended by the police chief, shall obtain and maintain at its sole cost and expense a security detail for the function room. Reason, I think some of that is obvious, but during the course of the hearing, we were informed that the licensee has in fact, on their own, secured security details for the functions. And that's good, and this will help continue that along.
Okay? All set, board? Any comments from the board? Counselor?
Yes, we object to that provision. And I think it's a bit of overkill. Let's say, for instance, that the Cohasset Harbor Inn is gonna run a baby shower or wedding shower on Sunday and have 35 people in that room. Does it make sense that the manager has to call the police chief, and the police chief then makes a decision as to whether or not a security detail should be assigned?
Is there gonna be amplified music there at the baby shower? Maybe that's the key
Yeah,
discussion.
this is a
Well,
license for
there's no
entertainment.
mention of any amplified music
Well, I'm saying
How about if
maybe
we
that's the
added that?
difference.
in
How
that
about if it-
paragraph.
Like I said, citizens should confer with the police chief as to the nature of any functions which will have amplified music. Something.
Why would that drive a security detail, though? I mean, I'm a
This is
little
a-
uncomfortable
yeah.
with this language.
And this is only an entertainment license.
Yeah.
So it would only be for events.
I gotta say, I think
What-
this is overkill, right? I mean, is that what you're getting at?
I'm getting there, yeah, I think it's overkill. I think first of all, it is only on, the baby shower isn't a great example, cause you're not exercising the entertainment license for the most part at a baby shower.
Unless it's
You
a-
might,
I don't go to them,
Misbehaves.
so I don't.
right,
Okay.
I've been to a few.
Are we sort of feeling that having the police chief involved in maybe these functions is not,
I think,
is overkill?
and I think
So we
we've done
could-
this.
Don't take the whole thing.
Go ahead, Diane.
Yeah, no, I think that the Red Lion Inn has done this, and other venues in town have done it where they inform if there's gonna be a larger than usual, or maybe there's a comedian coming in, or, I don't know. I think there's a way to tailor this so that it's only for some issue, if there's an anticipated issue in the exercising of the entertainment license.
I gotta say, I, as a person who's owned restaurants, I think this is too invasive. I
Yeah.
just,
In general?
I get a feeling of calling in the local police on, no.
yeah. I mean, I would, Cambridge would never make me do something like
And
that.
the idea is, I don't think,
Yeah, I would say just take it
cross it,
off.
cross it out, folks,
Just
with the
take
name.
out all of it.
Fine.
You okay with that, Counsel?
Yes, thank you.
I mean, certainly, if you feel you need to or want to,
We could put it in.
then, or don't, just don't.
Yeah, and if it
It's
gets
at
to
their
be a
discretion.
problem in the future, and hopefully it won't, that's something to consider.
Yeah.
So I'm gonna take out that.
Take that paragraph out. Next one?
Okay, now, new number 4, which used to be number 5, licensee shall undertake the installation of speakers on the patio for sound coming from the function room, should be there, with speakers facing towards the building and away from the property line, with the intention that any sound will be directed back towards the building and not towards off-site locations such as the residential area. Only soft music such as dinner music and music conducive to conversations shall be played on the patio. The last sentence sort of repeats the theme that the patio is supposed to be, soft music type place. The idea, and this was my idea, I know some board members have already
They
told
have their
me,
hands up.
there are concerns about it. I have seen in another venue where there was a problem with noise to the residential properties in the area, that they got speakers for the patio area. They were disguised to look like rocks, and you couldn't even tell that they were there. And B, they were positioned such that they were directed towards, in this case, the ocean, and so away from the property owners. It was just a suggestion. We'll have
Okay,
strong
Steve and
feelings.
Diane?
Yeah, once again, and I'm gonna piggyback onto Jack's observation previously. How the license holder decides to deal with the conditions of the license is their management prerogative.
Yeah.
It's ours to determine whether or not there's a violation that's occurred after a complaint comes forward. I don't believe it's either our duty or very bright of us to direct how speakers shall be employed or not. And frankly, I think this gets into an area of intrusion that's not necessary.
Okay, I would tend to agree with what's with Diane.
Yeah, I just think putting speakers on the patio basically is amplifying music on the patio, which we just, under the other
We have to make an
license.
exception, if you're gonna go this way, I understand that this is
So,
not, you know.
I
your
think
favorite
we should get rid of
provision.
it.
I'm feeling we get rid of
I
it.
would agree, I would agree.
Okay, Counselor, do you have any comment?
I think,
Do you object to us, Gary?
no, I think it can go.
Next one?
Okay, now, new number 4, before number 6. Licensee shall engage a sound engineer to examine the operation of the venue and recommend ways that sound can be prevented from being heard beyond the lot line. Licensee shall also explore installation of sound barriers in the patio area and elsewhere to prevent sound from being heard beyond the lot line. Licensee shall report to the licensing authorities the report from the sound engineer and the results of any other steps taken to reduce noise.
Yeah. Jack, would you like to comment on that?
Again, I don't know if we want to be in the acoustical design business, okay, so.
And in addition, the neighbors have pointed out that previous operators were able to manage the sound in a way that was harmonious with the neighborhood. Before we start to prescribe conditions that actually add substantial, well, a cost for certain to the business, let's see if the business can harmoniously coexist. This might be a next step, but I'm not convinced that it's necessary right now.
Yep, I would tend to concur with that.
Yeah,
Paul?
and I'm sorry.
Paul?
Yeah, I tend to agree. I think this just means good business management. If we tell them what to do, I'm sure already, or should be looking at ways to muffle the sound, whether it's tree barriers that you wheel in, or a sound, or closing the doors, or changing the site of the speaker. All of that is beyond, I think, the purview of our ability here to.
Present interest. Jack?
I'm sorry, I forgot.
Okay.
Yes.
My
We're
gist,
not in
the
favor
gist
of
I'm getting
the
from the board
language.
is that we're not gonna entertain, that we're gonna knock this one out too.
But I don't know if Mr. Lawler wants to comment on, because we did have some discussions, we'll take
No,
the
I'm
language
gonna
out.
invite him to.
But,
Do you have any comment on this? We're gonna take this paragraph out.
No, that's fine, thank you.
but I think you
All
did
right,
say
yeah.
that you did, we did talk about having a sound engineer consider things to minimize sound, and I don't know if there's anything you wanna tell the board about that or not.
No. I said that earlier, that.
And we're
we
making
try to
clear
reduce
what we
this.
want as an end result in terms of noise, communication. This can get more simplified.
I just
so-
wanna work on tailoring this
Right, that's,
to a document, and then, I mean, I can make other comments afterwards.
you're invited to if you wish right now. Do you wish?
I don't wish to.
Okay.
Okay. Next
The
and.
next
what's the
one
last
is now new number 4, which I think before would have been number 7, the last item. Licensee is advised that further noise complaints or the failure of the above to sufficiently address noise complaints will result in further administrative action.
Yeah, I think that sort of goes without speaking, and I wouldn't, this
I wouldn't,
even,
yeah.
I want our latitude open. I mean, obviously, we expect our
I think
rules to be
that goes.
followed, or there'll be consequences. Any,
Yeah,
Diane?
just for clarification, these are conditions on the license that we're discussing, so I do think that number 4 is more appropriately put in maybe a letter that attaches the revised conditions on the license.
It's essentially the summary of our action.
Exactly, as opposed to a condition.
That's right, it's not a condition of the license.
Right.
It could determine it.
Right.
But
okay?
I think on that, are you gonna keep it in or strike it?
No, it's
Strike it.
Strike it.
Okay,
Gone.
okay. No
So,
comment then.
okay, so, try to move this along. It seems to
Yep.
me we've gone through this and we've come to the items we've come to agreement with as a board generally, we need to vote on it first. Have you got that recorded?
Yes, yeah, if you want, I don't know if this is doable with Tracy, I could accept the changes, email it to Tracy, she can then print it out, and you can see, Mr. Lawler also can see what we've done tonight here.
Yeah, if you can do that now, and we can, if you wanna, and does the
So
board wanna
maybe I'll-
take 5 minutes while that's getting done, or do you wanna stay in session?
If we could take 5, that'd be
Okay.
great.
I'm gonna
Okay,
email
what
Tracy
we'll do
to
is I'm
Chris.
gonna ask,
You sure? Yeah.
ask for a motion to, adjourn for, I mean, to take a 5-minute recess.
So moved.
Make a mo,
And
second.
a second, all those in favor say aye.
Aye.
And, so we'll adjourn for 5 minutes so that that can get done, and when we come back, we should have before us what the new license will look like.
That's fine.
Welcome, folks. We're now back in session after a 5-minute recess, during which time we provided, we tidied up the language of the license that we're now going to be reflecting on, just so that the audience knows. What I'd like to do is, this here is what we've pretty much agreed upon. Counselor, why don't you just run through it quickly, or you?
Sure.
Just, you don't have to read the whole thing, but just go through the highlights, and
Yeah.
you can look at it, selectmen, and it should.
I'm just gonna try to compare it to one of the earlier versions, the one that was attached to the memo. from
That's, well, why don't you go through with
Yeah.
what we now have as our final
Yeah.
product, so.
So number one, there were no changes about applicable laws remaining, applicable. Calling the attention of the licensee to Cohasset rules and regs. Number three, name and cell phone numbers of all managers will be on a list distributed to the town, the police, the residents, and posted at the front desk, function office, and function room. Any changes in personnel or cell numbers shall be distributed to the foregoing within 7 business days of the change. Employees shall attempt to respond to calls concerning issues promptly and with courtesy. And when appropriate, managers shall work with area residents, the town, the police department to address noise and other issues. Management, that should be a numbered item.
Should be number 4.
That should be number 4. Management will be mindful and acknowledge the license is in an area, it should be mindful of and acknowledge the license is in an area abutting a residential district, and shall remind hosts of all functions and guests leaving the establishment that they are in an area with residences, and to exercise good judgment in terms of any noise. Management is responsible for educating its staff as to the conditions and limitations of all licenses. Venue, Breeza, no amplified music on the patio, that's from before. Non-amplified music on the patio must cease at 10 p.m. Number 3, windows and doors, windows and the word "and" being added, including accordion doors leading to the patio, must be closed by 8 p.m. except for ingress and egress. Doors and windows shall be closed whenever amplified sound produced in the function room will be unreasonably audible beyond the lot line. For the patio, same thing from before, as to the dining venue, will dancing permitted as an incidental activity. Weddings are considered acceptable. Number 5, a suitable staff person on the premises shall be tasked with responsibility to ensure that the doors are kept closed at 8 p.m. or earlier if amplified sound produced in the function room will be unreasonably audible beyond the lot line. Okay, all venue and all licensed premises. Entertainment is permitted until 1 a.m. Monday through Sunday, so long as it is not unreasonably audible beyond the lot line, except for occasional noise caused by temporary opening and closing of doors for ingress and egress. Windows must be kept closed when entertainment license is being exercised. Doors to be closed except for ingress and egress, except for accordion-style doors leading to the patio, which shall be closed by 8 p.m. while the entertainment license is exercised. All windows and doors shall be closed whenever amplified sound produced in the function room will be unreasonably audible beyond the lot line. We struck a couple of things there. A suitable staff person on the premises will be tasked with the responsibility to ensure that the windows and doors are kept closed by 8 p.m. or earlier if amplified sound produced in the function room will be unreasonably audible beyond the lot line. And that is it.
And just correct the spacing there between
Yeah.
2 and 3.
Yeah,
All you need to do is change the spacing there and put a number of 4.
yeah,
I have just a couple minor things. Under venue Breeza, number 3, just unreasonably is misspelled, there's an extra A in there.
Okay, I did not run spell check then.
And then
Reason
for,
one, I believe.
and then right up above, you're gonna add mindful of. And should, I can, might be too picky, just tell me so, and say the acknowledge the licensed premises is in an area abutting the residential district? Or is it
Okay.
okay to say that the license is in an area
The
abutting?
licensed premises, I think is better. Licensed premises
That's it.
are in an area abutting a residential district, okay.
Yeah. That's it.
And, where was the unreasonable, I'm gonna run spell check.
Unreasonably is
It would
under
be in the
Breeza.
singular. It would just, Can I have a comment on paragraph 4?
Let me just,
I'm sorry.
Diane, where did you,
Under venue Breeza, number 3, the last line, be
Oh, okay.
unreasonably.
Yep.
Swanably.
okay,
Reasonably.
Okay,
all right.
I think, Attorney Muller might be saying that in number 4, up in the general conditions, it should be singular, the licensed premises is in an area,
Licensed,
or is it R? If the R is,
licensed premises.
I don't know,
If it's
That the
Something
licensed
else.
premises,
if it's
we said
plural, it's
licensed
R.
premises are,
premises,
If it's plural, it's our
yeah.
Maybe it is.
yeah.
Okay.
There are two functions.
Okay, wait a second, let's see, do you have a comment, Counsel?
Well, on that paragraph 4, the last sentence where it says management is responsible for educating its staff as to the conditions and limitations of all licenses, I think we should narrow that down to the entertainment license. I mean, it makes sense because we're dealing with the entertainment license. There's no need to educate everybody about other, I don't, I've never run a restaurant, I would imagine there's other licenses, that might be too broad.
Okay, so the question before us, do we wanna,
And just take out
To make-
of the licenses and put in.
just say in
This
this
license.
license.
and
This
limit of this license.
this license?
Help me, where are we?
First, general conditions, number 4, and you're on the last word.
Take
Of
all
all
licenses.
licenses, of this license,
Oh, didn't make it this license,
Just make it license.
of this license, yeah,
okay?
yeah.
All right, Counsel, anything else? All right, he's all set?
Nothing further.
Okay.
Anything else further,
No.
ladies, folks, men, women, everybody? We got it all?
Uh,
Or not yet? Let me know when you're done with the
Yeah.
document.
When the board approved these licenses, all the licenses before, and the licensee was in agreement, we had it at the bottom, adopted by the Board of Selectmen on the date of that hearing, June of 2016, and agreed to by licensee. So can I add today's date? Are these considered agreed to by the licensee?
Well, I think they are, I just wanna go meet with my client and go through them word by word, but I'm pretty sure.
Yeah, I think from a legal point of view, we don't need to have that agreed
No.
to, all right?
Not by the licensee, no, but I'm
Doesn't have to have
I'm gonna delete that and just say adopted by the Board of Selectmen, April 12, 2017.
Perfect. You could say, yeah, okay, yeah, just leave it there, okay? And so that's it, and then,
Okay, let me just
so,
run,
let me know when you're done, so I'll
Yep.
want to address with the board.
and, okay, and I'll take out my date, JBL 4/12/17, that's just a note
Yeah.
for me. I'll take that out. And I think that is good. Okay,
What's that?
I just Googled premises, it can be used as either singular or plural.
Making good use of your time over there. Thank you. You won't be sending us a bill for that, will you?
Curious minds want to know.
Hold it up too.
That's all right.
Okay, we set with this now? Because I wanna go to the next step.
Licensed premises, I have as licensed premises are.
No, that's
It
okay.
doesn't matter. No one's getting crazy
Are
about
you
that.
set? What we done with that?
I'm set.
Okay, so now what do we do now? We've come to agreement as to what the conditions of the license, so what would be the procedure now,
Okay.
Counsel.
Uh,
the steps?
Notes. Okay. I gave you some suggested, on the memo that I gave you.
I think unless
on
I'm
page
missing the
2.
board, unless I'm missing something, I think from the board, we may wanna look to issuing the license with these conditions. Do we wanna do
Well, I
anything else?
address it here,
Do you wanna review that then, or?
on page 2 of the memo that I sent you.
Right,
Um, I have a bunch of fine, votes and motions.
okay, I'm just trying to get mine out here. Yeah, right
It
here.
was what I passed out.
Earlier?
Yeah, it's
I
on my
think it's right
letterhead.
here. Is this it?
No?
I'm assuming that's the reason.
There it is.
Yeah, page 2 of
Okay, so, so page 2 is, if you're all there, if you have it there.
So A
The
1,
bold
2, B
part
1
of
through
it.
C.
it, starting with A.
But haven't we done this already?
You
So should we
did,
read?
the stuff at the top, if you start like in the middle of the page where it says A, based on the findings made.
Yes, do you want me to read, do you think I should read
Well,
this?
that's a proposed motion, subject to modification by the board.
Okay, so
Copy for me.
proposed motion to be based on the finding and the failure to protect the failure to
Well,
protect.
okay.
I thought we already made this finding is what my question is.
This then provides background.
This is,
cover for
we
the
made
action.
findings that the incidents occurred as alleged, factual,
Yeah, but we already
Yeah.
made that finding.
You made that finding before, and on the memo, I have the votes that you did before, and you also found that it was a violation of the entertainment license. So this is just tying it all together.
Right, okay, it just sounded in the present tense, but that's okay. In view of the above findings and findings on March 7th, someone could make a move to, okay, then we can either issue a reprimand or a stern license, a warning to the licensee. We can modify the license terms or conditions by making the following changes, and that would be what we just did, and we could approve the renewal as just amended by the bill. So what we could do is do number 2, or does the board wanna send a letter?
Well, there'll be ultimately, after tonight, assuming that this is the final proceeding, there'll be a written decision that will be done up that will incorporate your findings. And I know some had suggested that there be on record, a reprimand or a warning to the licensee as well.
Okay, my own view is I'm not sure we need to do that. If we made these findings, and we've changed the license, and we're gonna create a record of it, and we're gonna issue that as a formal ruling, seems to me, that seems pretty clean, unless we wanna do more. Diane first, then Steve.
Yeah, my question is on A, because I think even though we voted to actually find a violation of the entertainment license on the incidences that are noted there, CAD 16, and the other one, we didn't specify the reasons, although we had the reasons, we deliberated on the reasons, but I think what we need to do is perhaps take a vote on, based on the findings made as to the violations, we find that the licensee did 1 and or 2. Does that make
Well, I
sense?
think what you have,
We did
it was
that already.
both 1 and 2. Failed to protect members of the public from disruptive conduct. Based on the incidents occurred,
Right,
and then you found that those
The
incidents
violation.
constituted a violation. And now you're saying here that the violation was that by that conduct, they failed to protect, this is the language of the statute, failed to protect members of the public from disruptive conduct, failed to prevent an unreasonable increase in the level of noise in the area caused by noise generated by the licensed activities, and as such violated the terms of the license and chapter 140.
So we are voting on A.
I would recommend that you vote on those three, A, B, and C.
So we're on A, B,
May I?
yes, Steve.
Moved that, based on the findings made as to violations on September 25, 2016, at 8:08 PM, CAD number 160-48036, and at 9:04 PM, CAD number 160-4804, we find that the licensee, 1, failed to protect members of the public from disruptive conduct, 2, failed to prevent an unreasonable increase in the level of noise in the area caused by noise generated by licensed activities, and as such violated the terms of the license and general laws, chapter 140, section 183A.
Second.
Okay, any further discussion? All those, we'll do a roll call vote on this. Jack?
Aye.
Diane-
Jack and Eily, aye.
Diane Kennedy, aye.
Kevin McCarthy, aye.
Paul Schubert, aye.
Steve Gomer, aye.
That's unanimous, Tracy? Go ahead. Give them-
Okay, second motion, in view of the above findings, and findings made on March 17, 2017, move to issue a reprimand and warning to the licensee due to these violations. Any further violations will result in administrative action. Number 2, modify the license in terms and conditions by making the following changes to the license. Okay, as noted in the document distributed this evening. Is that acceptable?
From what you just said, you left out the word stern.
I purposefully so,
No, it's fine with me, I just want to note that so that
yes.
the letters.
No, at this point, though, I want to make sure that we are citing the amended document properly.
I'm gonna send it to Chris, and he's gonna print that out so that you will have it.
All right, if I may repeat, number 2, modify the license terms and conditions by making changes to the existing license as accepted by the board this evening, April 12, 2017. And
As
and
reflected-
attached here too,
Yeah,
okay? C, item C, additionally, approve the renewal of the license as just amended for the balance of the calendar year 2017.
Okay, that's the motion, is there a second?
Second?
Okay, is there any further discussion? Hearing no further discussion, we'll call for a roll call vote.
Jack and Eily, yay. Aye.
Diane Kennedy, aye.
Kevin McCarthy, aye.
Paul Schubert, aye.
Steve Gomer, aye.
Okay. And that does it, then, right?
That concludes the hearing.
Is there anything else we need to do? No? Okay,
Close it.
that being said, I'll entertain a motion to, wait a second, we're still in a meeting, let me just grab the agenda.
Well, you can close the hearing and then
The
close the
hearing's
meeting.
closed, so.
The hearing's already been closed.
That's right.
Do anything.
So we're set on that.
I want to just check with Chris, he mentioned something about this, but I don't know if it's taken care of already.
Topics not reasonably anticipated yet.
Okay.
So this matter's over for those who are listening, and we're gonna just wait to town man on another issue before we
Okay.
motion to adjourn.
My excuse?
Yes, sir, thank you.
Thank you.
Thank you.
Thank
Have a
you.
good one.
You want a Girl Scout cookie?
No, thank you. Gave him up for Lent.
All right. First one.
That thing, I'm trying to get out of here.
Dispensation from working yesterday.
This here, what we just voted on, did call for a warning or something, is that gonna be encompassed in everything he does?
Yeah.
That would be my preference, okay. Make sure that he does it all in one document. I don't wanna write a separate letter. I can avoid it. Just make sure that everything we voted on is in all in one document, including the warning, okay?
Yeah, that'll be in the minutes and in the decision that I'll write up.
So this is it, right?
That's, yeah, two-sided.
We're all set then, huh?
Would you want, do you have a copy of that for attorney?
Yes.
If they don't.
Yeah. Chris is making. Are you making more than one?
I'm surprised, I didn't think they were gonna get it.
Yeah.
Not yet, Chris has just a quick thing.
48 hours. Thank you.
Yeah, sorry.
Good night, good night.
Good night, folks.
Thank you for your support. John, there's a copy there.
Okay,
Thank you, Counselor, for working.
thank you, good night.
Yeah, generally, up to this point, aircraft carriers when they're different presidents. Or battles.
See you guys.
Thanks.
Okay, and now I'm gonna rely on, Chris and Attorney Landkey to prepare whatever paperwork needs to be prepared to finalize what we did, okay? I don't know what do we need to sign this at the next meeting or something like
Well,
that?
there'll be, I'll do up a decision hopefully by your next meeting.
We'll cover this next meeting and perhaps sign off on it and all
Yeah.
that, yeah.
For
I'm
the
relying on,
license, you know, once the staff does the license, that'll be ready to be signed.
okay, so you can fall through on that administratively.
Not showing it. It froze.
They what?
Picture froze.
Okay. What are you doing?
Yeah.
And I'm watching the live feed.
Yeah, my husband said it wasn't coming through.
Perfect, that's okay.
Are we not there? I can see me.
We're being sent to the system, but it's not being broadcast properly, so.
Right.
They'll figure it out at
Okay.
headquarters.
So what do we got?
Okay, any topics that are not reasonably anticipated by the chairman within 48 hours? Was there something?
And I just need you folks to sign, re-sign the warrant document, because we had a little technical snafu with the sign.
For the sign,
copy.
okay.
So,
So sign that now,
yeah, and that's it.
okay? All right. I'll entertain a motion to adjourn.
You need,
So moved.
So moved.
Second, any further discussion? All those in favor say aye.
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 This meeting is adjourned. Thank you, folks.